freedom of testation, which is a right that everybody has. Anybody who's above the age of 16 has, to actually go sit down and draw up a will and decide in terms of who needs to inherit out of their estate. So that opportunity of sitting down and drawing up a will gives you an opportunity to choose who's going to be the executor of your estate, who's going to benefit from your estate, and who's going to be a trustee, and you get to nominate a guardian of your minor children. However, if you pass away dying intestate without a will, we've got the laws of intestate succession, and they actually dictate what needs to happen when you pass away without a will. And I'll briefly explain what law of intestate succession actually says. It says when you pass away, it looks what we call next of kin, in inverted commas, we can look at bloodline. And that actually dictates who's going to inherit. If you are married with children, depending on your marital regime, it will go first. The portion that goes in terms of the marital regime will go to the spouse, and your share will go to the spouse and to the children. And if there is no children, it will just go to the spouse. If there's no children and there's no spouse, it will go to your parents. Failing parents, it will go to brothers and sisters. Failing that, it will go to cousins. So it looks at bloodline.
The spouse gets something, the kids get something. To me, it sounds like, well, that's okay. That's what I want to happen. But in Ed's case, as we were talking before, it kind of was that, when you die, that doesn't necessarily mean what you actually want to happen. Because that, I think, to me, interstate sometimes feels like, I'll just leave it and it'll work out the way I want it to. Maybe, David, do you want to comment?
Yes, the problem in this case of this particular gentleman is that he was married in community of property and owned a house. And yes, in terms of the community of property marriage, the surviving spouse, in this case the wife, would obviously be entitled to 50% of the house as part of the joint estate. The balance of the estate would then be split, and she would get a child share out of his half share, and the rest of the estate is shared amongst the children. The big problem is that she can't afford to maintain the house. There's a bond, she's not employed, so she would want to sell the house, but she can't, because the property is now going to be transferred in the name of minor children. They would now have to approach the High Court to get permission to sell the property, and I know from experience that permission is very, very difficult to achieve, and it's costly. So just simply doing a will, leaving the house to her, could have saved her a lot of hassle. Now she's lost her husband in a terrible accident, no will, there's total confusion, and she's in a terrible state. And the law can only help her so far. The Intestate Succession Act is there, but it doesn't take you all the way.
Absolutely.